Hi everyone, I'm Jessica
And I'm Lisa
from the Balanced Real Estate team in Prescott, Arizona. In today's video, we're going to go over some things you should know and what to do when you have heirs who will inherit your home or personal belongings and other items when you pass away. Now, this is not legal advice. You probably need to speak with an attorney about your estate, but hopefully these are helpful hints about what to ask. And don't forget, if you like what you are seeing on our channel, be sure to subscribe. We understand that talking about passing away can be a little morbid, but it's better to talk about it now and make a plan for your estate so it doesn't become a huge problem later.
Okay, let's get started. Let's say you have bank accounts or pension accounts. What should you do on those accounts prior to passing away? Well, the first thing you need to do is make sure that everything has beneficiaries, because that's what facilitates the transfer of those assets from the person that has deceased to the heirs. This is super important, and we cannot stress this enough, to have a trust. A trust will help avoid probate.
Probate is messy. It's very expensive and very time consuming. A probate will cost tons of money and attorneys will need to be involved. And here's the secret. Attorneys charge a whole lot more to oversee the probate process than it would cost for an attorney to draw you up a trust. Okay, so what about personal belongings? Say there is a beautiful piano or an antique desk or a vehicle. This is considered personal property, which is usually outlined in a will, and a will is generally attached to a living trust. The will is for personal property and the living trust is for larger assets, as we mentioned, a bank account or a personal account, big ticket items as opposed to personal property, such as maybe a vehicle, a piano, or mementos.
Here's something important. Don't just lock your will and trust documents in a safe somewhere. This is a big no-no. Why is it a big no-no? Because no one can access that safe and no one will know those documents even exist. Have your attorney hold on to a copy if you want to keep the documents or contents of the documents private, and make sure your heirs have the name of the attorney. Generally, your attorney will draft the documents anyway. The attorney will ask to see the death certificate and then he can release everything to the heirs. Okay, so next, the deceased owns a home and that home has utilities, of course, and the utility companies still need to be paid, along with HOA fees and whatever bills that are involved with that home. So here's a good idea. Use a notebook to keep those accounts written down with usernames and passwords available for someone to log in. I'm not telling you to put your bank account passwords or information like that in the book, but simple things like your utilities, HOA information, insurance, car insurance. You want to have those things readily available where someone can easily find them. It will allow your heirs to log in and change the billing information from you to them. This is important because once you pass away, the funeral home reports your death through Social Security within days of your death. And then a lot of other institutions are notified of your passing. Your bank accounts will be frozen if you don't have somebody else as a joint person on the bank accounts. If it is frozen, you could have a problem with possible automatic payments for bills, insurance, car payments, whatever, that doesn't get paid. Then that sets up many other problems because obviously, well, you're dead, you're not around. It will be much easier for your heirs to be able to log in and change the billing information from your bank account to their bank account to keep the household going.
Something else we recommend is once a year, take a statement from all the accounts like utilities, insurance, bank, and whatever else, and let your heirs know where you keep the information. It's important your heirs have account numbers. That way, when they contact institutions, the heirs can provide information about your passing away. They can share the account numbers, provide the death certificate, and make sure that banking can release funds to the beneficiaries.
Social Security will notify the banks and a bunch of other institutions of your passing. I know this firsthand because when my dad passed away, it was just a couple days after that some credit card companies came a-calling and they wanted the outstanding balance paid in full.
As As we mentioned before, you may have some accounts frozen. The Social Security Administration is actually pretty good about stopping payments. What you don't want is that Social Security is still depositing into the deceased account and then the heirs have to return that money to Social Security. If the account keeps getting deposits from pensions, then your heirs will have to notify them and possibly return that money if payments have been made after your death. It's important that you, as the heirs, get certified copies of the death certificate. It used to be that you needed several copies of death certificates to provide to every entity, but fortunately not so much anymore. A lot of institutions will accept scanned copies. What is really easy is to order the death certificate from the funeral home and they can have copies mailed to where you live. So if you live out of state or if you are leaving town, no problem, just let them know where to send those copies. Pensions, retirement plans, and those types of entities will all need a copy as well. Most of the time, they will accept very good scanned or copied documents.
Okay, so let's talk about if the deceased has a vehicle or two that they left behind. Well, more than likely, the vehicle is titled in the owner's or deceased's name. The DMV can help you out with this. They have a couple of forms for you to fill out, and you'll retitle the vehicle usually either in the name of the estate or in the name of the heir. So then you can keep the car or sell it.
Okay, so let's talk about the house that the deceased owned. So there are a couple of options. The heirs could keep it as a rental once the heirs obtain the title, or the heirs could sell it. But either way, here's where the utilities come up again. It will be really important that utilities stay on. Personal property will need to be removed, and that means everything will need to be out of the house, including the garage, basement, attic, the storage shed, everything. The heirs will need a copy of the death certificate and a copy of the trust and will, or whatever documents gives the heirs the authority over that property. So if you have to go through probate, you will have a court document that makes you the executor or the trustee. However the court works, you will need those documents in order to list the property for sale. And you will need to provide those documents to the title or escrow company in order for them to process the sale of the property once you have an accepted offer.
In regard to signing any documents, in most places, this can be done remotely, so you don't have to physically be there. Most contracts can be signed via electronic signature like DocuSign or AuthentiSign, and any closing documents that need to be notarized, those can be signed remotely as well. If you are here in the United States, it's a little easier. The title or escrow company can also send a mobile notary, even if you're local and just don't want to go into their office or don't have the time. But there's usually a fee for this service. If you're overseas, it can be more complicated depending on the title company. You may be able to do it electronically using Skype or Zoom so they can identify you. Most of them will require that you make an appointment at the U.S. Embassy in whatever country you're in. If that's the case, make an appointment well in advance, as some embassies are really busy and it could take months to get an appointment.
Now let's talk about the seller's property disclosures that the seller must provide to the buyer once in escrow. What if the heirs have never lived in the house they inherited and don't know anything about it? This is a great question, and we run across this all the time. You will still need to fill out the disclosures to the best of your knowledge. There are portions of this document that you probably won't know, but if you know there is a homeowners association, you'll need to contact the HOA and find out what the fees are and if they are upfront fees, disclosure fees, or maybe there are assessment fees. If you know there were some improvements completed at the property, you will need to disclose that as well. Okay, so the home is in escrow and the buyer wants several repairs complete before closing escrow. Do you have to do the repairs? First, discuss with your agent. If they are simple repairs and maybe the repairs don't necessarily require contractors and scheduling, and maybe it's something easy that one of the handy heirs can handle. But if the heirs or sellers are out of town, generally we recommend that you as the seller offer to credit the buyers rather than doing actual repairs, and here's why. If the buyer backs out of the purchase, then the next buyer will have another inspection and a different set of repairs. And crediting the buyer keeps you from having to have come out of pocket with expenses on the front end. By giving the buyer credit at close of escrow, credit funds will come from proceeds at the end, so heirs won't have that upfront cost. So next, what happens when the deceased had a loan on the house? Well, the loan doesn't just get wiped out and everyone walks away with a pile of money after it's sold. Oh no. If the deceased had a loan on the house, then the loan gets paid off from the proceeds of the sale. And here's something really important. A lot of people think that in a reverse mortgage means that the bank gets that house back. This is not true. The bank wants the money, not the house. With a reverse mortgage, you have 6 months from when the deceased died until the house has to be sold and the heirs have to make good on the loan. But heirs should not wait to get that home listed. Heirs should list the home as soon as possible because depending on the market, that house could take a long time to sell.
So how do heirs get paid after selling the deceased's home? Well, after the home is sold and the outstanding loan amount gets paid, then the heirs get paid. The trust documents will designate how the remaining money gets paid to the heirs. Escrow prefers to wire the funds, then it will take 1 or 2 business days for the funds to arrive. So the home closed escrow, so be sure to inform the homeowner's insurance company that escrow has closed. The insurance company may take your word for it, or they may ask to see a settlement statement from the title company. They'll process a refund for whatever is left of the premium, so make sure that you give them the correct address to mail the refund. As far as the mortgage company, if there's a loan on the property, let the mortgage company know where to send any funds that may be due to you. Usually there will be an impound account, which is an account used to pay property taxes and maybe home insurance, and those impound accounts get dispersed about 6 weeks after the loan has been paid. But we encourage you to call the mortgage company about a week after closing to confirm they have the proper address to send those funds. Otherwise, they'll send it to the old address or the address that's on the loan. Next, make sure the utilities are out of your name. We tell clients to call the utility companies a few days prior to closing and have them taken out of your name on the date of closing so you don't keep paying those utilities if the due owner forgets to put them in their name. If your city or town takes care of water, sewer, and trash pickup, call the town and let them know the home has been sold and take your name off the account.
Now, if the heirs plan to keep the home, and this is really important, get an appraisal as soon as possible after the deceased has passed, as especially if you're going to rent it long term. You will need to establish the basis for the value of the property at the time that the recently deceased passed away. This is really important down the road when you go to sell the property because now taxes will be due on the difference between the value of the property at the time of that person's death and the new value. Otherwise, you'll be dealing with the value from when the recently deceased actually purchased it 50 years ago, and that's a much different tax bill. Okay, one last very important thing. There could be tax issues and heirs should speak with a tax professional or tax preparer. Even though the person has passed away, a tax return will still need to be filed for the year the person dies. And maybe even 2 different tax returns may need to be filed. One for the state and one for the home. And it may have to be in 2 different years. Maybe the person passed away in 2023, but the house was sold in 2024. So remember, this is not legal advice, but just some general information. So please seek advice from an attorney or tax professional.
If you're thinking about moving to the Prescott area or planning a trip to visit to see if it's right for you, we're here to help. If you already live in the Prescott area and are considering a move, we can help you get to where you want to be. Are you ready to start your search for your Prescott area home? Go to PrescottRealestateandLiving.com. Don't forget to like and subscribe to this channel and help others find this valuable information. We post home tours, neighborhood tours, buyer and seller tips and tricks, real estate sales stats, the best things to do in Prescott, and much more. Check the comments below for our contact information and to request buyer and seller guides or a relocation package. Thanks for watching, and we'll see you again soon. Bye-bye.
Bye.